Is the IRS coming for your cryptos? Hey everyone, Adam Bergman here, tax attorney and founder of IRA Financial. And on today's Adam Talks, the Kraken IRS battle, the John Doe summons, and the overreach of the IRS in terms of trying to get your taxpayer information on your crypto trading history. So we've seen the IRS do this in Coinbase. They've been attacking Kraken. And finally, we have a court ruling by the Northern District of California, June 30th, 2023. They actually have a split ruling. They rule in favor of the IRS, obviously, because the IRS has enormous summons power. Essentially, they can ask for almost anything they want. But in the case of something called a John Doe summons, where they actually don't have, they're asking for information from a group of unidentified people. So instead of saying, hey, I want all the taxpayer information for Adam Bergman, they're saying, hey, I want all the taxpayer information for anyone that traded cryptos from 2016 to 2020, which could be hundreds, thousands, tens of thousands. Just send me all the info. That's basically what they asked. And I'll get into some of the interesting parts of this case. But essentially, the court, they had 5 requests for information, and the court ruled in favor of the IRS on a number of them. But thankfully, I think fairly, basically said, hey, a couple of your requests are just overreach, and you can't get that type of information, like certain wealth information of the client. Like, yeah, you can get their names. We'll give you their social security, their address, but we're not going to give you their wealth information, where the money came from, their asset value, wealth, things that you don't need to go and audit someone, right? So this comes down to, and obviously this is focused on non-retirement accounts, right? I generally speak of retirement accounts, but I wanted to talk about this summons because it goes to the heart of the IRS's focus on cryptos, right? The SEC, CFTC, they're focused on regulatory aspects of cryptos. Who's regulating these exchanges, trying to protect the consumers from fraud, breach of trust, malfeasance, bad actors, poorly designed, APIs in the crypto platforms. And the IRS is saying, hey, we don't really care about that stuff. We just want our tax revenue. And we think there's millions of taxpayers out there that are buying and selling cryptos and not paying any tax. And yeah, we're now asking on the 1040, top of the form, to basically indicate if you've ever traded cryptos, but we don't trust people. So we need to go and get information from the exchanges so we can actually audit these folks, because we don't think they're being forthright in their tax reporting. So that's what's going on now. They did this with Coinbase a bunch of years ago. Who knows what other exchanges they've done it with. Kraken decided to fight. I'm assuming a lot of other exchanges just caved in and just gave the IRS everything they wanted. But from Kraken's standpoint, I think they really try to preserve customer data as best they can. And also, it was a major burden to try to produce some of this information. So they tried to get this summons narrowed. Now, they knew they were going to lose the battle. You never are able to basically squash an IRS summons. It's almost impossible. It's just not something done. There's Internal Revenue Code section 7602, 7609. Essentially, if you read it, it gives the IRS incredibly broad summons power to go and make sure people are paying their tax. So the tax code obviously protects the IRS. When it's something like a John Doe summons, there's something called the Powell Doctrine, which comes from a 1964 case that basically says in order to get information, in the case of a John Doe summons, where you're asking for a group of information or information from a group of unidentified taxpayers, you need to show 4 things. You need to show it's issued in a legitimate purpose, the summons. 2, the summons seeks information relevant to the purpose. 3, seeks information that is not already in the IRS's possession. And 4, satisfies all the administrative steps set forth in the code. Okay, so if you can prove those elements, then you could, the IRS has the ability and legality to go out ahead and issue a summons and collect that information. And that's what they did with Kraken. This was a multi-year battle. And essentially, they asked for information from 2016 to 2020 for all account levels, basically all information required above $20,000 in trades. Okay, that was their limitation. Say we're not asking for everything. They're saying give us all user information. Then anyone engaged in transactions exceeding $20,000 within a calendar year, including their names, pseudonyms, birthdays, taxpayer identification numbers, addresses, phone numbers, emails, and other docs. Okay, so under 20K, we're fine. We don't really care about them. Over 20K, aggregate of transactions in a year, we want all their info from 2016 to 2020. And Kraken decided to fight. I give them credit for doing that. They knew they were going to lose. I assume they were just trying to limit scope, protect customer data as best as they can, and make their life easier to comply, because this is millions of dollars of legal fees to comply to these summonses. When I was my first year as a lawyer, this was after 9/11. I was a tax transactional lawyer, but guess what? There's no work, right? 9/11, there's literally no transactions. The world stops. So I get put on this tax summons case, and I spent like a year going through doc data, doc review, squashing summons, doing research on the Powell elements. So I know this stuff really well. And ultimately the IRS won, but we did get to narrow the summons a little bit. We had a privilege log. We argued, privilege, and we were able to narrow the scope because it was overbroad. Now, the IRS, they have the power and they like to use it. And that's the scary thing with providing government agencies more and more power, more and more agency budget breadth, is it breeds a beast. And I've seen it. And, the folks at the IRS are good people. Like, they're not mean, horrible people. They have a job to do. And the problem is they're pushed to go hard and hard. And it creates a really bad dynamic, because the cost of complying with these summonses, if you're a small business, you're done. They could put you in bankruptcy. You basically just tell the IRS, come in and take whatever the heck you want. I don't even care. I can't fight you because I can't afford the legal fees. Kraken's bigger, so they're able to fight. Same with Coinbase. And let's see what happens. So the IRS's argument is this. This is in a nutshell, and this is statistics they have from several government accountability office reports saying, hey, in 2013 and 2015, only 800 to 900 taxpayers filed tax returns that showed they own Bitcoin or virtual currency. And we know Coinbase had 6 million customers and handled 6 billion in transactions. So we know there's people not reporting this stuff. Okay, so we know there's an issue. Now, they gave more data. They said in 2016, 88,000 taxpayers reported cryptocurrency transactions. 2017, 93,000. 2018, 102,000. 2019, 253,000. 2020, 842,000 in 21. So we know it's growing, but we don't think these numbers are nearly where they should be. This is like a fraction of where it should be in terms of reporting taxable income from cryptos, because we know crypto is a capital asset, right? It's not cash, it's property. Just like you buy stocks, you buy real estate. When you make money, you pay tax. If you hold that capital asset, that crypto, that stock less than 12 months, you pay ordinary income tax. If you hold it greater than 12 months, you pay capital gains tax. The IRS is saying, hey, show me the beef. Where's my money? And that's what's going on. And that's why they're pushing this. And I get it. If I worked at the IRS, I was the commissioner of the IRS, I'd say, hey, there's billions and billions of dollars of tax revenue we're leaving on the table. We need that money. It's only fair. If we don't police the stuff, it's going to go unhinged and people are never going to report this stuff. I get it, right? My issue is the summonses are super broad. Okay. Now, the fact that the IRS was even looking for some of this stuff, which I'll go through. So what did they look for? They basically said there are 5 requests. The first was, give us all the account registration records, right? Who owns this stuff, right? Give me their info, their name, their phone number, email, all the stuff they talked about. Give me their user preferences, their user history, payment methods, how they funded this stuff, their user profile, account application records. Like, I get that. That's fair. I get it, right? Number 2, they asked for any other records of know your customer due diligence performed with respect to the user, not included in paragraph 1. So this is a little broader. It's like, hey, do you really need that stuff to go and audit people? Seems like that's going above and beyond, and you're actually looking at our procedures as Kraken, not the taxpayers. And then third, all correspondences between Kraken and the user or any third party with access to the account pertaining to the account, like emails. That's support logs. That's also a bit much, right? That's not going to help the IRS audit someone. What do you need that stuff for? Then 4, all exception reports produced on any anti-money laundering, all records of investigations. The request does not include SARS or any stuff like that. And then 5 is all the transaction history, things like that. Okay, so what's going on is Kraken gets this in the mail or by email, and basically they call their lawyers and they're like, well, what do we do? The lawyers, I say, look at this stuff, and they say, well, out of 5, there's a couple things that look super broad. We got to fight them. And that's what they did. And they basically told the IRS, we're not giving you all this information. And then the IRS said, yes, you are. So they went to court. And the IRS, again, said, hey, we need this information to audit people. It's the only way we're going to do it. People aren't reporting this stuff. We have a responsibility. Here are the Powell elements. We can show relevancy. We can show we need this stuff. And we can show there's no other way we can get it. Kraken's like, hey, we get it, but this is super overbroad and unfair. How the hell are we going to produce all this millions of documentation? And what did the court said? Okay, and the court basically said, we agree with both of you. Request number 1, right, which was all the customer data. They basically said, you need the info, the government. You're already limited to $20,000. Yeah, it's fair. We're going to let you do that. 2 and 3, right, which talks about like the know your customer, the correspondences, all that stuff. Nah, doesn't seem like you need that stuff, right? That seems beyond what is reasonable and necessary to achieve the purpose of these requests. Okay, so we're not going to give you them, which is fair. And I think that's what Kraken was looking for, because they're like, that's going to take us millions of dollars and thousands of lawyers to go through all these emails, chat requests, logs, user support logs, to go through this stuff. And what do you need it for? You know their name, their email, their address, their ID number, their social. Like, you can audit these people. What do you need this info? This is the issue with the IRS. It's like, you're pushing. Why are you pushing? Why are you doing that? Why are you putting this burden on a private company? Why are you doing it? Or a public company? Either way. Why? You're not going to ever look at this stuff. Like, why are you doing this? That's overbearing. Now, request 4, basically the court, and request 4, just to remind everyone, was basically all exception reports about anti-money laundering, which I think is overbroad. The court basically said it's not overbroad, and it's not burdensome because Kraken has this stuff. And but I disagree. I don't think the IRS actually needs this stuff to audit someone. If they want to get this stuff from Kraken, I don't think they're the right agency to do it. Maybe it's CFTC, maybe it's the SEC. I don't think they're the right agency, but they got it. And then 5 basically is all records of activity in the user's account. What did the court say? The court said basically, they said it's overbroad to the extent it seeks records that go beyond Kraken's transactional ledger. So they're like, we'll give you transactional ledgers for activity report, but anything that is beyond that, you're not getting. So essentially, what are they getting, the IRS, right? They're getting anything above $20,000 from 2016 to 2020. Name, birthday, ID number, physical address, or social, telephone number, email address, and all documents relating to the Kraken, like anti-money laundering, and then anything relating to transaction ledgers. Otherwise, they're not getting. Still a crap load of documents, right? Millions of pages of documents. Coinbase had a much limited scope. It was like 56,000 records. Now, Coinbase is bigger than Kraken, but you're talking probably hundreds of thousands, if not millions of folks that got caught in this web. Now, what's going to happen? The IRS is going to have your information, and you're going to get audited. Now, maybe your statute of limitation ran, 3-year statute of limitation, unless there's substantial understatement. But you're hoping if the idea from the IRS is that, hey, if you didn't report this stuff in 2016, you probably didn't report in 2020. So we still have 3 years to go after you, or it's getting close to that. And we're going to nail you. And they'll probably start at the end towards the 3-year number, so they can make sure they're getting people. Now, according to the Coinbase, according to the court pleadings and filings, they were able to get about 95% of the Coinbase group. They were able to actually find them and audit them. Now, it doesn't mean they actually pursued an audit. Maybe the statute ran. Maybe people actually paid the tax, but they found 95% of the folks. So the idea is that here in this group, whether it's 100,000, a million, they're going to find 90+% of you, and they're going to scare you to start paying. And the whole point of this is, even if the statute ran, they want this publicized. They want to scare people into obviously complying with the tax code. I get it, right? You buy and sell cryptos and you make money, pay your tax. I get it. Okay. I understand what the IRS is doing. I don't like their approach. I think it's overbroad. Just ask for what you need. Don't try to be difficult. Don't try to impose all these costs on companies for no reason. You don't need this information. All you need is their name, birthday, and social or ID number. Like, let's be honest, that's all you need. You can go in your database, find out who you are, and pull your return, see if you reported your crypto gains. It's not that hard. Really not that hard. So again, not to be really fair, which I am, but obviously I'm subjective. I own most of my cryptos in a retirement account. Why? Because I don't want to deal with the tax. I'm a long-term player. I believe in cryptos long-term. Yeah, I think there's some bad actors now that need to get shaken out, whether it's FTX and some other exchanges. I think someone needs to come in and clean things up. The exchanges need to be able to prove their reserves. They need to prove insurance. They need to step up and show they're segregating accounts and are not commingling funds. So I think exchanges need to be certainly audited with more scrutiny. But I still believe in digital assets, blockchain. But I'm a long-term holder, hodler. I'm looking where cryptos are in the next 10 to 15 years. So I'd rather put in a Roth IRA, wait till I'm 59 and a half, and hopefully I have tons of gains. That's my play. I could win, I could lose. Who knows, right? Volatile, no one knows. But that's my game. That's my strategy. So I don't need to do it in a taxable account because I don't want to pay tax. I don't need to be part of these John Doe summonses. I'm sure every exchange in the United States got these summonses. Just Kraken and Coinbase decided to fight them. I don't need the IRS on me. So that's why I use a retirement account. And I think this summons is just greater enforcement of the value of using a retirement account to buy cryptos. Not only does it mesh well with the long-term strategy of cryptos, long-term growth profile, but from a tax standpoint, you're not going to get into this web of complexity and potentially a web of IRS scrutiny because there's no tax to be collected because it's in a retirement account, which is the beauty of all this. So that's it. I give Kraken credit for fighting this stuff. It cost them a lot of money. And the IRS was going to get what they wanted, but I really want to show this case because it goes to the heart. And again, I know people that work at the IRS, DOJ, like they're good people. They mean well. Same with the SEC. But it's like, hey, why are you pushing for all this extra info? Like, just ask what you need. Why are you doing that? Like, what games are you playing? You may get it. Let's say you get it. Let's say Kraken or Company X just said, you know what, IRS, just take whatever the heck you want. We don't care. Well, you're not going to look at it. You don't have time to go through all this stuff. You have the name, the social, the address. It's all you need to go and Google, go up, search on your database and find Adam Bergman, pull my 1040 for the last 20 years and just see if I reported crypto. It's very simple. It's a checkbox. If I didn't check the box, audit me. You don't need all this information, additional information that costs companies millions and millions of dollars to collect, and just violates individual privacy to a greater degree that's necessary. So I'm really happy that the Northern District of California Court shot it down. I give them credit. I think the right outcome materialized. Remember, the IRS can get what they want. They have huge summons power, especially John Doe summons power. So just beware if you're buying cryptos and you're selling at gains more than 20K using U.S. exchanges. The IRS is going to find out. Okay, so think twice. Definitely report it when you're filing the 1040. Check that box. Talk to your accountants. Report. These exchanges provide really detailed transactional history. Give it to your accountant. Report this stuff. If you're using a retirement account, enjoy. Sit back, relax, because you don't have to go through all this nonsense. And hopefully, right, in the next 5, 10, 15 years, we all can celebrate together. So that's it. I hope you guys enjoyed the podcast. I didn't mean to scare anyone. It's just the way this works. The IRS has enormous powers. You don't want to fight the IRS. And that's why individuals don't fight them. We don't have the money to do it. Kraken's a big company. Coinbase is a big company. individual small businesses fold. We have no choice. Who has millions of dollars to fight the IRS? That's what this stuff costs. Probably multiple 2 to 3 years litigation. So that's probably $3 to $4 million in legal fees. And now you have to comply. That's probably millions more dollars of doc review and collection, because there's some privileged material maybe, and you got to make sure you're actually providing the proper information, right? You're not just giving information of individuals that don't fit this $20,000 time period. So a lot of work. I've done it. It's great for law firms, bad for everyone else. So thank you. Enjoy your day. Hope your summer's going great. Thanks for hanging. I'll see everyone again next week. Ciao.